Hello, Cyclones. Today we're going to go through a presentation on the Family Educational Rights and Privacy Act, also known as FERPA. First of all, in order to talk about FERPA, I think we need to understand what it is. FERPA is a federal law that protects the confidentiality of student education records. FERPA applies to all educational agencies and institutions that receive funds under any program administered by the Secretary of Education. FERPA affords parents certain rights with respect to their children's education records maintained by educational agencies and institutions to which FERPA applies. These include the right to inspect and review their children's education records, to seek and to have their education records amended, and to have some control over the disclosure of their educational records or personally identifiable information. These rights are then transferred to the student at age of 18. All right, here's what's protected under the FERPA Act. Records directly related to a student that are maintained by a school or maintained by a third-party vendor on behalf of the school. Here's what the list of things that are protected for students. Their student grades, their immunization and health records, their disciplinary records, student progress reports, academic or physical testing results, grade point average, and attendance records. Things that are not protected are private records a teacher makes during the course of teaching, law enforcement or campus security records created and maintained solely for law enforcement reasons, employment records. Employment is contingent upon enrollment and attendance. Alumni records and graded by peers papers. How does FERPA impact your classroom? Be careful with technology used in your lessons. Don't use websites that require your students to enter personal information unless it's been approved by a supervisor or the school's technology officer. Find out what companies or vendors your school is working with and or feels comfortable working with. Continue to evaluate the technology you and your students utilize. Keep any data you have secure. Store your students' data and information using your school's data management systems. Don't email information to unverified parent email addresses. Keep any physical graded material or grade books in secure, safe places. And don't discard student information, don't discuss student information with others. All right, a little bit about video surveillance in schools. The Fourth Amendment allows us to video. When video surveillance recordings are made in locations where individuals have a low expectation of privacy, such as when they're in a public place or in movement and actions are in plain view. Some examples of those are school hallways, stairwells, school buses, school parking lots, and even classrooms. School districts should notify the school community through policy, statements, and handbooks and signage that cameras are located throughout the school, and individuals should anticipate having their image captured. For how FERPA plays into this, FERPA also provides parents and eligible students the right to access education records. Images of students captured on surveillance recordings qualify as education records when photo or video is directly related to a student and maintained by the educational institution. Some camera guidelines: developing and publishing policies, describing the purpose of surveillance cameras on the perimeter and for their use, installing cameras only in areas where individuals have a low expectation of privacy. Notify the school community the use of surveillance cameras via your policies, handbooks, websites, newsletters, and signage. Consult with legal counsel prior to enabling audio recording. Audio recording has some issues and does not typically hold up in the court of law. Establish protocols for maintaining equipment and retaining recordings and apply them consistently. Develop protocols governing requests for disclosure, including the handling of requests for copies. A little bit about data destruction. FERPA does not require educational agencies and institutions to destroy education records maintained as a part of the regular school or agency operation, and in fact, many jurisdictions require lengthy retention periods for student attendance and graduation records. For other student records, in order to minimize information technology costs and reduce the likelihood of inadvertent disclosure of student information, schools and districts will often elect to establish their own record retention policies, including time frames for eventual destruction of the records, minimizing the amount of data you retain by destroying them when no longer needed. is a key element of fair information practice principles and is widely considered the best practice for protecting individuals' privacy and lessening the potential impact of a data breach or inadvertent disclosure. There's 3 different ways. First one is to clear, a method of sanitation that applies programmatic software-based technologies to sanitize data in all user addressable storage locations for protection against simple, non-invasive data recovery techniques, typically applied through the standard read and write commands to the storage device, such as by rewriting with a new value or using a main option to reset the device to the factory state. Second one is a purge, a method of sanitation that applies physical or logical techniques that render target data recovery infeasible using state-of-the-art laboratory techniques. And the last one is to destroy material, a method of sanitation that renders target data recovery infeasible using state-of-the-art laboratory technique and result in a subsequent inability to use the media for storage or data. So you're probably wondering how this affects you, and I have some suggestions for you. Make sure that you're careful with online vendors such as apps and websites. Make sure our school is compliant with those apps and that they are compliant with FERPA. Check vendors to make sure they are FERPA compliant. Educators should also be diligent on social media. If one person can see it, 1,000 people can see it. Be smart with what you post. Schools may disclose directory information, a blanket term for basic identifying data such as a student's name and address. Do not share sensitive information through email. It is not the most secure method of communication. All right, a little bit about District 70 and FERPA. This comes straight from our website. Disciplinary and attendance information shall only be shared with a criminal justice agency investigating a criminal matter concerning a student enrolled or who will enroll in our district when necessary to effectively serve the student prior to adjudication. Such information shall only be shared upon written certification by the criminal justice agency that information will not be disclosed to any other party, except as specified, specifically authorized or required by law, without prior written consent of the student or parent and guardian. School personnel who share disciplinary and attendance information concerning a student are immune from civil and criminal liability in the fact that they have good faith compliance with state law. Nothing in this policy shall prevent administrators, teachers, or staff from disclosing information derived from personal knowledge or observation and not derived from students' education records. Within the bounds of the state law, school district personnel shall seek to obtain such information regarding students as is required to perform their legal duties and responsibilities, including to protect public safety and safety of the student. Such information may be obtained from the Judicial Department or any state agency that performs duties and functions under the Colorado Children's Code. Continued, our school district personnel receiving such information shall use it only in the performance of the legal duties and responsibilities and shall otherwise maintain the confidentiality of all information obtained. School personnel who knowingly violate the provision are subject to disciplinary action and to civil penalty up to $1,000. If such information is shared with another school or school district to which a student may be transferring, it shall only be shared in compliance with the requirements of federal law, including the FERPA Act of 1974. When a petition is filed in juvenile court or district court and alleges a student between the ages 12 and 18 has committed an offense, it would constitute unlawful sexual behavior or a crime or violence if committed by an adult. Basic identification information as defined in state law, along with the details of the alleged delinquent act or offense, is required by law to be provided immediately to the school district in which a juvenile is enrolled. The information shall be used by the Board of Education to determine whether the student has exhibited behavior that is detrimental to the safety, welfare, or morals of the other students or school personnel, and whether educating the student in the school may disrupt the learning environment in the school, provide a negative example for other students, or create a dangerous and unsafe environment for students, teachers, and other school personnel. The board shall take appropriate disciplinary actions, which may include suspension or expulsion, in accordance with the Student Code of Conduct and related policies.